Hey, good morning, everybody. I see we got no eyes on the YouTube thing there,
Oh, it's
so
coming. It's coming. You got to give it a second.
get ahead, get started anyhow. There we go. Happy Wednesday. How's weather down there in North Carolina, young man?
I was just telling you, I have I'm inextricably wired into my psyche now. I walk out in some spring mornings as it starts to warm up and spring turns to summer here in North Carolina, and I have these vivid memories of 3-a-days during football season. Pre-football season, really, before summer workouts really kick off. And, I think I was telling you that if you're not familiar with the southeastern summers, um, you can very easily mistake the air for something that you can drink as well as breathe. So
Well, well, that's not my thing. I'm a northern New England boy. Well, southern New England by a week, but northern New England when I can. So welcome back to Law and Legitimacy. Lots to report as always every day. I'm on jury selection in a murder case, which is a particularly fun experience because what I learned is just how unusual we are here on Law and Legitimacy because we plug in every morning. We talk about public affairs. We have an interest in the news. Some people are passionately interested. Some, like me, are passingly interested. Some, like Mike, are somewhere in between. And we try to reach consensus on issues of public concern. Some people just don't care. I mean, the number of people who don't watch the news is stunning. I actually had a person on the witness stand. Again, Connecticut has individual sequestered voir dire. That means we get to question each and every juror outside the presence of all the others. And this is a person who I don't want to say a whole lot because I want to protect, even though it was an open court, I don't want them to feel as though I'm talking about them, even though I am. But this is a person who worked with young children and didn't really pay any attention to the news and didn't really pay any attention to politics. So I took a gamble. I said, do you know who's running for president in 2024? And she paused for a moment and she said, no, not really. And I thought, wow, she is among the blessed, perhaps, and I wonder how many people really just don't pay attention to it all because it's all such a roiling mess. And here we are raging against it every day, Monday through Friday, trying to make sense of it.
it may be that the real world is now remarkably quiet as compared to generations past, right? And by real world, I mean, just being in physical reality. I imagine, there aren't as many newspaper stands. The frenzied energy of, how news used to make its way to people just isn't that way anymore. It's almost entirely dominated by internet information, right? Social media primarily. And so if you're not someone that's adopted social media or integrated your routine or evolved your routine to incorporate that, I'm kind of I may be jealous, I think, of how quiet it must be out there.
Well, I can tell you that I am progressively unplugging from social media. I participate in our stream because I enjoy talking to you, and I enjoy talking about public affairs, and I think there's a value to it. But I no longer check, X for information. It's been years since I maintained an active Facebook account. I've got one. I don't know anything about Instagram, and I just find there more nourishment in face-to-face communication, service of my client, communication with my wife, and with my kids, and that the world is filled that way. So
Well, Justin Wright, you are the first. You are the inaugural tip giver. So we'll have to give you some sort of special badge for you to wear. Thank you for the $10 tip. Justin says, too true. Ignorance is bliss. Wish I was ignorant some days. I think we all are ignorant to some degree or another, right? But again, I think primarily just a huge thank you to you.
yeah, thank you very much, Justin. Obviously, this means a lot to us. We'd like to monetize this stream so that we had the ability to spend more time on it. We both continue to practice law. I note by way of anniversaries that it was 1 year ago today that I wandered back into my office after a near 6-month absence in the Proud Boys trial. And what a year it's been. I think that the roiling effects of all of the stress associated with the Proud Boys case, with with the Alex Jones case and with several others makes me feel, in some respects, like I'm a returning war veteran. And sitting at this desk 1 year after, I realize how the after effects and aftershocks of that case ripple still. We took a pass on filing, the office did, Owen Schroyer's certiorari petition to the United States Supreme Court, in part for financial reasons, but in part just from a need to step away from it all and take a new perspective. Robert Barnes did file Owen's petition this week, or at least the Barnes Law Group did. And it's a good petition. I glanced at it last night. It raises the issue that we preserved in the DC Circuit Court of Appeals, whether protected speech can ever be used as circumstantial evidence of an implicit conspiracy. That is whether that's the issue in the Proud Boys case. In Owen's case, his protected speech was used to prove what? That he engaged in trespass. And so the notion that politically protected speech can be used to prove the elements of a crime in the context of an assembly of people to petition for the redress of grievances is probably an issue of first impression for the United States Supreme Court. I don't know whether they will bite on it in Owen's case. We're going to make an effort to preserve it in the Proud Boys case. It's an important issue because speech matters. And on that topic, we're following a story in, I believe it's North Carolina. What's the young man's name?
Christian McGee, and he's 16, so the lawsuit actually just designates him as CM. But this is something that we reported on briefly when it first happened a couple of weeks ago. So it's Davidson County, North Carolina, and the defendant in this lawsuit is actually the Davidson County School Board. And yesterday, the Liberty Justice Center, in conjunction with local counsel out of Raleigh, North Carolina, filed a federal lawsuit on Mr. McGee's behalf, alleging, among other things, violation of his First Amendment rights in connection with his being suspended for a 3-day period by the school following an incident in class where he apparently asked the teacher a question and distinguished on the subject of alien by asking whether space aliens or illegal aliens without green.
Let me reframe that a little more precisely. I don't mean to be critical, Mike, but I think it's important because the context matters. It was a writing class of some sort, and the students were asked to use the word alien in a sentence. And he asked, you mean like space alien or illegal alien? And his use of the term illegal alien in that pedagogical context created a stir in the classroom. One classmate threatened to quote unquote kick his you-know-what. And it turns out on press reporting this morning that may not have been a serious threat. But the point is that in this context, in a purely pedagogical context, teacher says, use the word alien in a sentence. And the boy says, like space alien or illegal alien. That created a stir in the classroom. And the result was not a moment.
Or did it? I think that's so. The complaint actually argues, Norm, that there was no commotion. So maybe we start with the Tinker standard. Are you familiar with the Tinker standard? The first.
Yeah. So Tinker versus School District of Illinois. This was a case, I believe, in the 1960s. And the lead language from that case is that neither students nor teachers shed their First Amendment right at the courthouse door. And so in Tinker, this was during the Vietnam War, and a student wore a black armband to protest the war and to protest draft for the war, and he was removed from school grounds. The court held that those words were not sufficiently disruptive to the school's pedagogical function, that is, its purpose in teaching people, to require his removal. And that this student, notwithstanding his young age, as being a student, had the right to speak and to express himself on this highly significant matter of public concern. And so in this case, in the CM case, we live at a moment where if we're not quite yet at the fever pitch we were in terms of protesting the Vietnam War, many people have much to say about immigration. And illegal immigration. And therefore, It is a fraught topic. It is a topic laden with emotional energy. So in this case, on application of the Tinker standard, I could see people arguing it both ways. And you'll say, what? On the one hand, he uttered speech, which is protected. If in fact it created disruption in the classroom, what should the response have been? The school has the right and duty and responsibility to provide an education to others. It seems to me that were I a justice, I would conclude that CM's First Amendment right were violated shocking way. This wasn't CM coming to school with an extracurricular badge and indicia of his political view.
Right, because in the Tinker case, we're talking about students coming together wearing black armbands and actually creating a disturbance in the normal course of the school day. No?
Yeah. And in this case, the kid responded to a question the teacher asked with an example from the news.
So I think I was telling you this morning, man, this complaint is damning because it's not even as it was originally reported. So imagine that the news doesn't have all the facts quite together. But I think fair, right? Because reasonable minds can agree that in the context of something like this, perhaps there was an adversarial relationship between the students, and the teacher was doing something to try and throw cold water on an escalating environment. But it doesn't appear, based on the face of this complaint, that is at all the case. So it is English class. CM actually took a restroom break and he came back to class. And so I'll just read directly here from the complaint, Norm. Upon his return to English class, the word aliens was used during class discussion. CM raised his hand and asked Ms. Hill whether the reference to aliens referred to, quote, space aliens or illegal aliens who need green cards. Hill responded and said, "Watch your mouth, CM." R, a Hispanic male student in CM's class, joked that he was going to, quote, kick CM's ass. Class otherwise proceeded as normal. CM's question about whether aliens referred to space aliens or illegal aliens who need green cards was not racially motivated or targeted at anyone, including Hill or any of his classmates, nor could it be reasonably viewed as obscene. So it goes beyond that. During the lunch period, this teacher apparently reported this to the school administration, and both students were called into a meeting with the assistant principal and the teacher. And R, who's the student that joked that he was going to kick his ass, actually told the administrator and the teacher that he wasn't offended at all, that it didn't disturb him. And in fact, these two students are friends. They have a good relationship with one another, which is why R would have indulged that comment to him, "I'm going to kick your ass," kind of thing. So what we have here is actually, and the reason I have, how will the Tinker standard be stretched? Or in the alternative, I think in the title of this video, I said the Heckler's veto. What do we do with a teacher whose subjective interpretation of an otherwise neutral exchange like that changes the course and scope of how disciplinary procedures as set forth in the student handbook are applied? Because as this complaint describes, Norm, there is something in the handbook that talks about this, right? But there's also something in the handbook that talks about violence between students and an enhanced burden upon the administration to mete out discipline proportional to those things. In this case, CM, the plaintiff here, was suspended for 3 days, but the other student who said, "I'm going to kick your ass," and admitted to saying that, was only given some sort of in-school suspension for about a day. So there is a comparison between the discipline as applied by the school unto the two students, and principally there's an issue of whether this speech embodies anything that reaches that standard as established in Tinker. And I can scroll down while you take it from here to get to that legal standard as referenced in the complaint.
So it seems to me that the school district missed an enormous opportunity to place the two boys on a podium and to have them have a discussion with one another in the class about what those words meant and how those words made them feel with respect to one another, so that the class could begin to confront differences of opinion in a principled way with an aim at mutual understanding, and if not reaching a common a common understanding about what to do, at least understanding that there were principled reasons for each taking their position. criminalizing, ostracizing, using the heckler's veto. If you make me uncomfortable, therefore you cannot speak. That shut down the discussion. And I think the school board missed an incredible opportunity. Paragraph 73 of the complaint, Mike, says under the Tinker framework for school officials to regulate student speech, they must articulate facts that reasonably have led officials to forecast the speech would cause substantial disruption or material interference with school activities, or show substantial disruption took place on a school's premises. Candidly, if one of the functions of schools is to educate people to become citizens, that is to learn to live together and tolerate differences and debate one another on differences of opinion, the school failed in its educational mission here objectively, and began to view itself more as a sort of factory of producing orthodox thinkers rather than producing people who can think. I remind everybody of the obvious here. Get your Aristotle's Politics down and look in book 3 of Aristotle's Politics, and you'll see that one of the defining characteristics of citizenship, of a person being a citizen, is their capacity to deliberate with others. That is, to exchange points of view, to try one another's points of view on, and to work together to attempt to arrive at consensus. And if they can't arrive at consensus, they can at least arrive at an understanding of why they don't agree. I think this case is really a significant failure on the school board's part. I suspect that they will settle with CM. It's a public entity, so it won't be a private settlement. Those are settlements with public entities are subject to Freedom of Information Act. But I think the school district needs to apologize to CM. I think it needs to apologize to its parents. I think it needs to apologize to the school district in general, because what this case represents is a failure to educate. It's funny. I mentioned moments ago that I'm picking a jury here in New Haven, Connecticut, and I had a juror, a 30-something juror on the stand, and I was asking her questions. And among the questions I asked is, do they even teach civics, in high school any longer? And she couldn't recall. And it seems to me that this is an example of why we need to have civic literacy. We need to have an education in how to talk about differences. We need to have an education in how to listen. Arthur Brooks wrote a fascinating book, How to Love Your Enemies. My wife gave it to me a while ago. I read it years ago. I'm rereading it again. And basically it says, that rather than revolving or devolving to a culture of contempt, we need to sort of take the religious admonition to love one another more seriously. That is, to listen to one another, and to take the other's point of view in ways that suggest we care for one another's opinion and therefore for our own. It's good advice, I think. I mean, we try to model it here. Mike and I last week debated, whether it's time to begin to consider a hate speech exception to the First Amendment. And the CM case illustrates the weakness in my position, and I concede that, because if the view is that we are going to regulate speech that has no redeeming value, an extreme application of that point of view would be, and in this school district's view was, basically ostracizing or quote unquote criminalizing the use of a term that is in common parlance, illegal alien. And those of you who criticized my emerging view last week for saying it was standardless and opened the door to a slippery slope, can use this case as an example and say, see, Norm, we were right. And I will concede that, yes, you are. And that creation of a standard with traction is going to be a difficult matter. So let's keep an eye on this one. I predict a settlement in the range of 50.
Yeah, I don't think, like I said, I think the face of this complaint is really damning. I think if I think back to what I was saying or how I concluded on the stream when we first introduced this a couple of weeks ago, I think I said I was apprehensive to see, what the facts really are as it related to the classroom. But the things here that stick out to me are, number one, that he missed the first part of class because he was on an excused bathroom break and then came back asked the question, and then one of his, the person in the class that said anything was actually his friend, and then that friend subsequently said that he wasn't offended, and there was disparate treatment in the discipline provided. That all speaks to me in pretty great volume. It also strikes me that the teacher here, if we're just looking at the face of the Tinker standard of substantial interference or interruption, the teacher is responsible for creating the substantial interference or interruption with school activities in this case, right?
Yeah,
Or at least on the face, if we take the face of the complaint as true, that really looks more to be the case here. We've got some comments over here. I just want to acknowledge. Walk to here says the teacher made a mountain out of a molehill. Exactly. Suspend the teacher, maybe, or at least I don't know what the I'm sure that teaching is suffering the same sort of competency crisis as law enforcement is these days. The public teaching profession is not as reputable as it once was. I can remember, teachers that had an active hand in shaping the person that I became, the student that I was. And I also recall, as we all do, those teachers that were mailing it in or were otherwise self-righteous in their own sort of idiosyncratic ways. It seems as though, not to reduce a person to the sum of, one instance of conduct, but it does occur to me that this teacher saying, watch your mouth to a student, I think it was also in this complaint that the teacher was on record as having asked the guy that, the student that said, I'll kick your ass, is on record as asking that Hispanic student why his grade was what it was, implying it was low. So there may be sort of a discriminatory angle to even the way that this teacher had treated the student that she was allegedly protecting in this context, which I think is also ironic. Goodfella D, tenure for teachers in NC makes it difficult to purge bad educators. Let's see, there was another one. Yeah, a teacher who turned a student question into a suspension and a lawsuit. Get rid of the teacher. Yeah, look, at this point, I think that the teachers union is going to be actively involved. The prayer for relief here is asking for monetary damages in addition to the sort of equitable relief. So you mentioned an apology, Norm. Obviously, they're asking for that apology, but they're also asking for the suspension notification to be expunged from the record, to remove the unexcused absences that are embodied in that 3-day suspension. And then to remove all references from his record that he used any sort of racially motivated or inappropriate or insensitive language in class. So in addition to that apology, they're attacking the lack of due process, the void for vagueness doctrine as it applies to the conduct policy of the school and the district, I think on its face, but also systemically as to how it's applied. Is being uninformed and incapable of meting out discipline in any consistent and repeatable and predictive fashion. And then the monetary damages, I think, is really interesting. The plaintiff's mother came out in the early days of the reporting, if you recall, Norm, and she was harshly critical of the school, principally because her son is on a track to a 4-year institution and has aspirations of actually competing in college sports. And so I think that you and I both know that in this day and age of college applications and checking intersectional boxes, and then, combined with student records, a young white male from, rural North Carolina who would perhaps otherwise have the GPA and the test scores and the extracurriculars necessary to matriculate into an institution of choice is no longer the case. And we've talked about the Harvard case. We've talked about the UNC cases from earlier in the Supreme Court's term. As evidence of those rubrics and how they're used. Justin Wright, again, man, you're crushing us this morning. Another $5 tip. My brother spent 6 years in college to become a music teacher, all forms of music. He has been a teacher for 2 years now and is changing professions. Wow.
Yeah, well, I mean, I get it. So, thank you again, Justin. We really appreciate it. Spread the word. Your financial support is golden to us. It makes it possible, perhaps someday, to become a truly independent forum, perhaps even independent of the law. Hey, who is the law firm that is handling this CM case?
The CM case is being handled. So there's two, and I'll scroll down here to the bottom. But again,
this is very sophisticated and good work. These people.
Yeah. So Troy D. Shelton. I'm not familiar with Mr. Shelton, but it appears as though he and Mr. Craig D. Shower out of Raleigh, North Carolina, are kind of combining on this. Two firms, the Dowling firm, or maybe it's just one firm, the Dowling firm, but then it's principally, I think, sort of sponsored by the Liberty Justice Center. And M.E. Buck Daugherty III is one of the top dogs. The Liberty Justice Center is actually anchored out of Chicago. I was doing a little bit of diligence on that operation this morning. So you do have, I was tagged by a colleague a couple of weeks ago, seeing if there was any way that we could get involved in this case. But it appears that we weren't the only ones thinking that way. So,
well, good. Liberty Justice Center, God bless. I mean, they have financial support. That's what it takes to survive in this market. I'm an independent firm. We rely on individual clients with fees, and sometimes they have, sometimes they don't. And when they don't, we often can't get involved in the fights we wanted to get involved in. So, contribute to the Liberty Justice Center, contribute to us, let us get involved in the cases we want to get involved in. So let's switch over to Jalapeno Jack. I see he stubbed his toe this morning, or at least Judge Cannon pushed him in the direction of stubbing his toe.
Yeah, Mar-a-Lago, as I call it now, right? See you later, Jack. So Judge Cannon has delayed the start of the trial for the allegations of mishandling of classified documents indefinitely. There is no date to resume. And Norm, I'm not sure if you have been keeping abreast of the developments in this case, but it appears as though, and I sent you a post on X earlier this morning. Do you remember that and I'll bring it up here. Do you remember that picture that was circulating early on from I guess the FBI with all the top secret cover pages?
Yeah, I do. Yeah.
I'll put it on the screen here. Apparently this was staged in large measure. These cover pages weren't actually applying to any of the top secret or confidential or otherwise sensitive documents. This was done principally for what we're seeing on the screen, just shock value. And so I'll let you kind of take it from here. But our boy A.R. Hoffman from the New York Sun is absolutely killing it these days with the reporting. He reported on this on Saturday. He was sort of foreshadowing that there was going to be some issues here, and then boom, Monday, Judge Eileen Cannon basically looks at Jack Smith and says, "No, you've got some stuff to iron out here. Your candor toward the court, your disclosures to the defendants, and then also with respect to some of the other co-defendants in this case is completely out of line." I think Trump's legal team is now arguing spoliation of evidence based on the way that these things have been tagged, reordered, delivered. It's interesting to me.
So in a criminal case, the government has the burden of proof and the burden of production. It starts the case. They'll say, "Oh, you did this, and therefore we're charging you." But the government selects what crimes to charge and who to charge. And in the course of doing so, it'll assemble those bits of information that it thinks proves that the crime occurred, and will get a grand jury to issue an indictment. That is, to issue a true bill that there is probable cause to believe that a specific crime has been committed. And in the course of gathering the information to prove that that crime has been committed, a large database in a large case is created.
Your Honor, I was just fooling.
Yeah.
I was just funning.
And that database is called discovery. And so once a case is filed, there are discovery obligations that attend to the government to disclose some, but not all of its information. And paradoxically, the defense also has to disclose some information. I've always opposed defense discovery obligations on the grounds that I didn't pick this fight. I don't have a burden to produce anything. But, the court makes orders and you must comply with them. The Jalapeno Jack has treated this case as though it needed to be tried before the November election, but yet he has not been fully compliant, and perhaps neither has he been completely honest in his discovery obligations and his fulfillment of them. And Judge Cannon has basically said enough, and now she's delaying the trial. But, this is where I am more sympathetic to those who call these political trials. There is no urgency to try this case before November, other than its effect on the November election. I was ordered yesterday in another court, it's a state court, but to begin jury selection soon in a case that was charged in 2018. The case has lingered for 6 years, largely because of COVID. But it is not uncommon for there to be a long delay between the initiation of charges and the trial. And so Jalapeno Jack's false sense of urgency goes a long way toward proving the political character of these prosecutions. There is no necessity that the case be tried before November. Indeed, it should be tried thereafter, and there is very little question about that, especially if there are wrinkles in discovery that undermine not just the defendant's fair trial right, but the public's right to know just what's going on. I remind everybody that not only does a defendant have a Sixth Amendment right to a speedy and fair trial, the public has a right of access to the court. And that means a meaningful access to its proceedings. In federal court, there's very little that's done in chambers. Almost everything is done in a transparent fashion by way of pleadings and on the record. So if Jalapeno Jack is playing games with discovery, I think the public needs to know that. Because Jalapeno Jack has been claiming that this trial needs to go right away. And if it can't go right away because Jalapeno Jack has been playing fast and loose with the discovery, we need to know that too. And so let's keep an eye on the case. It doesn't look like it's going to take place before November. And that seems like the right result. I don't know enough about what's going on to say whether Jack's knuckles got cracked. I don't know whether there is enough irregularity in this case to call into question whether the prosecution can and should go forward. Prosecutors are largely immune from meaningful scrutiny in how they manage their cases. I'm sure the Trump team will press the claims against Jack and Jalapeno Jack as hard as they can. Let's see where it goes. But right now, score a partial victory for Team Trump. There will not be a Mar-a-Lago trial before November.
Absolutely not. And I do think that this puts a lot of wind in the sails. Not that many of you who watch us daily needed more wind in the sails. And I know we inherit a lot of criticism for kind of riding that middle road and trying to patiently report on this stuff and resist the urge to just call everything politicized or sort of arbitraged in bad faith. But this does lend credibility to sort of the coordination of the Department of Justice or the weaponization of the Department of Justice against Team Trump and any of those that are in his inner circle, those that would be responsible for what could be his next administration as president.
So I want to respond to a comment from Janet Smith, a regular listener, and that is, why do lawyers pretend kangaroo courts aren't happening? I don't know. I mean, I'm going to take this question first literally. I don't know what a kangaroo court is, but I do know that I've been involved in cases where I've been extremely dissatisfied with the court's rulings and apoplectic, filled with rage about the manner in which the courts have ruled. But I've never called a court corrupt because I disagree with how. I don't think I have. I'm sure if I have, somebody will find the public reference to it, and I'll be flooded with "you hypocrite, you liar," and I'll plead failed memory. I mean, look, I'm a lawyer, and I believe that when I go to court, if I master the rules that pertain to the dispute, I come to know the evidence that is admissible in the case. And I come prepared to argue, that's as much as I can do. I can't control the outcome. Like any trial lawyer, I've won cases that surprised me to have won and lost cases I was sure I would have won. And sometimes that's because I get a ruling that I don't understand or I think is wrong. Sometimes the jury simply disagrees with me. But win, lose, or draw, as a lawyer, I still think the rule of law is worth respect and worth respecting. And we don't always get it right in a courtroom. Everybody knows that. But what's the alternative? Those of you who are quick to call on kangaroo courts and to view the courts as corrupt, this, that, and everything else, I'm going to issue what I'll call the gallon of milk challenge. If you get a funky gallon of milk from a store dealer and you think that you've been wronged, where are you going to go? Are you going to go to a public health authority? Are you going to go to a police officer? Are you going to go to the storekeeper and ask for recompense? If you don't get recompense, are you going to turn to the courts for justice? And odds are you're gonna. So I would caution people against being too cynical about the courts, because without courts resolving disputes, we're going to be left to resolve them ourselves. And that is going to be in a way that is unbounded by principle, unbounded by legal precedent, unbounded by the rule of law, and unbounded by rules of procedure. Courts matter. Civility matters. Resolving disputes in a principled way matters. And when you lose, accepting that loss and seeking reform of the legal system or an appeal matters. Now, there are cases where the courts get it heartbreakingly wrong. And, so one of the most moving experiences I recall having was meeting a man at Jerry Spence's ranch who'd done 20 some years while innocent for a murder. And he didn't respond with the bitterness that you would expect. He didn't call the courts a fraud. The courts erred, and he forgave the courts, and he responded with love. And that love transformed him because he realized the courts are a fallible institution which did their best but failed him. And that's an attitude I accept. When it's my job as an advocate to make the best case that I can for my client. Sometimes I win, sometimes I lose. And when I win, I'm unbearable. It's great. I'm great. And when I lose, I'm heartbroken, and I look in the mirror and ask what more I could have done.
And I think that, what I sense that what people are searching for out of you here, Norm, is something separate from what you're answering. And I think these questions are fair, but I also think that they often overlook one key aspect of legal representation, which is a duty first and foremost and almost exclusively to the client, right? And the predicament that attorneys are in, particularly when there is a groundswell in an environment that attacks the integrity of a given case, right, or the legitimacy of a given case, or the charges or the claims brought. And I think Trump is a great anecdote, right? He's a great example of being able to kind of, I guess, analyze this and break out the anatomy. There are two different questions here, right? What is an attorney to do in the course of the case, but acknowledge the process as legitimate and fight vigorously along those lines and on that battlefield. And then what is an attorney to do out in the open? And, there's no one better than Trump to talk about these issues publicly. But I want to get to Janet's question here. Again, I think this is a very fair question, and perhaps the question is shaping the expectation of society as it relates to future litigators and future practitioners of law, right? I think I can tell you from having graduated law school less than a decade ago, that law school now has evolved into a model of this sort of practice-ready curriculum, meaning that, the market for legal jobs is diverse and different than it was 30, 40, 50 years ago. And many students have been conditioned to want that sort of work-life balance, whatever fever dream that ultimately is. And the role of state bar associations and sort of these cloistered, kind of claustrophobic older attorneys that kind of pull the levers on all these things, it does I guess disincentivize aggressive lawyering from perhaps more of the talented sort of independent-minded attorneys. And I say that because I started to practice on my own directly out of law school, and there's a huge burden on those that exist outside of the system to do so in a manner that does not expose the client base to that same level of risk or lack of I guess network. So in this case, I think that how many justice centers can we support? I understand, I get it, and I do understand that the economics of litigation have shifted such that the trial is something that is becoming maybe just being marginalized into history, right? The very few practitioners that I talk to on a daily basis are litigators, right? I talk to one every day, but that's because we do this show. So I don't know what the answer is.
No, I'm right there. And I want to address one other comment that I saw, and that is, which institutions are we allowed to be cynical about? You can be cynical about them all.
Right. That's kind of what I was trying to get to, is that there's two different questions being asked here, right? And I think that what people and Dawn principally want out of someone like you, Norman, it's not, maybe the question isn't fair for you, but maybe it is fair because you are you, right? And I'm not just blowing smoke and trying to bloat your ego, but I think that me being cynical about a case or a system or an institution is not a one-to-one comparison to someone like you being outspoken or cynical of a system, because it means something entirely different, because you're influential in a way that I am just simply not, and maybe not yet, but just not.
Yeah, no, I mean, I don't like, I recently said in the well of a court while a woman was being sentenced for murder, and I told the judge, I hate the criminal justice system. You know, I think that it is a fraud. I think that it paints in the dark colors of despair and pretends to produce things of beauty. You know, what we do is shuffle deck chairs on the Titanic and pretend that we've done something of value. But in the sentencing on the murder case, we don't bring the decedent back to life. We don't give the family anything really meaningful. There's no sense of closure that brings somebody back to life, and we push the killer into places of dark despair where we forget about them and marginalize them.
And perhaps we've been here before, Norm. I mean, I'm not old enough to remember the origins of, you know, Marvel and Capcom and sort of the comic book culture that led us to things like Batman and Superman. But there was a American culture at one time, especially in the case of Batman, understood that the systems were fallible, right? And that some sort of benevolent vigilante was necessary to shore up those iniquities. So again, I don't have an answer to the question, but I don't think the question is as simple as it might first appear to those that are asking. And I say that with all due respect and humility. I'm not trying to condescend. It's just, it's something that we get asked a lot, and you get asked more than me. But I do think that, you know,
and it's something I'll be thinking about, because I'm going to put on a jacket and tie and head over to court and resume jury selection this morning in a murder case. Our defense is self-defense. The issue is on videotape, and a jury's going to have to decide when it hears the law whether this whether this killing was justified or not. And as you look at the evidence, you know, you can see a lot of different arguments in it. And so in the end, the jury will have the power to decide. And I'd have it no other way. I'd rather have a jury of my peers make a decision about what to do in this instance than a group of experts who think they've known it all and seen it all. And that's the genius of the American criminal justice system. We still give to jurors the power to make life-defining choices, because we say that when it comes to the government's accusation against an individual, we want a jury of our peers to make that decision. Call me naive, but I believe in that, and I think it's worth fighting for.
Happy voir dire, my dear.
Thanks, Maury. Hey, so we're thank you very much for your support today. We would appreciate your spreading the word about us. You know, I'm looking to get out and do some more speaking to community groups about law and the rule of law and the role of legitimacy. Send the word out that this loudmouth in the Northeast and hadn't get in touch with us, and I'd like to come out and talk for an hour or two about what we see. We've got a message to spread. We want to spread a message of civility. We want to spread a message of inclusion and include everyone in the United States in a discussion about how to build better communities. We think we can do it. So
yes, and inclusion based on ideas, not on some sort of shallow intersectional characteristics, just to make sure we're not branded as overly woke here on the stream. Anyway.
Because I'm white, I'm not right. Is that what you're saying?
AMF Yo-Yo, you know where to find us if you're watching this still, which I know there are a lot of you now watching live with us in the mornings. Please make sure you have subscribed, that you have liked this video. And what helps us is things like what Justin Wright did with the tips, but also comments, right? So if you don't have any money to donate or to get your comment elevated and we don't get to it, the best thing that you can do for us is a simple like, a subscribe, and a comment. And we do appreciate every single one. Although I can't get to all of them, I do see all of them. And I try to shield Norm from some of the more harshly critical ones, because, you know, who cares about the haters, right? Ultimately. Anyway, AMF Yo-Yo, Norm, we'll see you tomorrow. Thank you, everybody. I feel like this was a really good discussion. We're going to keep abreast of the North Carolina situation. It's right here, just a few minutes from where I live and work. So we'll be back tomorrow morning, 8 a.m. See you then, Norm.
AMF Yo-Yo.
AMF Yo-Yo. Bye, everybody.